Mr. Secretary, close to 5,000 Marines and National Guards have been deployed to LA without the request or consent of the California governor or the Los Angeles mayor, Bass. Rather than calming the situation, this troop deployment is purposefully inflaming and escalates tensions. You claim lethality is your top priority. Do you plan to unleash this lethal force against U.S. citizens and civilians in LA and other cities?
Well, Senator, I would reject most of the characterization of that statement, including lethality against U.S. cities, when all of those National Guardsmen and Marines have conducted themselves with the utmost of professionalism, defending our federal agents, Americans, who deserve to be able to do their job to deport illegal immigrants after the previous administration allowed 21 million illegals to cross our border. I am not here to listen
to rhetorical responses. I would like to have a professional response that I would expect from somebody who is the Secretary of Defense. Millions of people peacefully demonstrated this weekend against the president acting like a king. Given this regime's dangerous policy of mobilizing troops inside the U.S., the politicizing of the military is a legitimate concern. So, given the dangerous policy of mobilizing troops inside the U.S., if ordered by the president, I'm going to ask you once again, to shoot peaceful protesters in the legs, would you carry out such an order from the president?
Senator, as I've said before, of course, I reject the premise of your question and the characterization that I would be given or are given unlawful orders. It's all meant to attempt to...
Today, a Senate hearing that cuts straight to the heart of a constitutional crisis. The defense secretary on the stand, tens of thousands of federal troops dispatched to U.S. cities, and senators demanding plain answers about legality and the possible use of force. What happened in that hearing, why it matters, and what it could mean for the rule of law, we'll break it down piece by piece. First, the facts. Approximately several thousand active-duty Marines and National Guard troops were mobilized around Los Angeles to support federal immigration enforcement and to secure operations, a move that drew immediate protests from local leaders and lawsuits from the state. Senators pressed the secretary on whether and how those forces would be used, who authorized them, and whether the Pentagon sees itself bound by federal court rulings about the deployment. These are not theoretical issues. They touch on the posse comitatus principle, separation of powers, and long-standing limits on domestic military operations. One of the most chilling exchanges came when a senator asked a direct surgical question: if ordered by the president to shoot peaceful protesters in the legs, would the secretary carry out that order? The secretary declined to accept the premise and refused to give a simple yes or no commitment, instead rejecting the characterization of the question while stopping short of an unequivocal refusal. A refusal to clearly disavow an unlawful order raises legal and ethical alarms. Under military law and long-established doctrine, unlawful orders, including orders to fire on peaceful civilians, should be refused. The hearing spotlighted the tension between civilian command, military obedience, and the protections afforded by the Constitution. Another central flashpoint: whether the Defense Department will comply with federal court rulings that might limit or reverse the deployment. When asked plainly whether he would follow a district court order, the secretary said, effectively, that district courts should not be making national security policy, and suggested the matter would be resolved only if it reached the Supreme Court. That answer drew immediate pushback from senators who viewed judicial review as fundamental to constitutional order. Federal courts have the authority to review alleged violations of law and injunctions.
Unlawful orders, it's all meant to attempt to smear the commander-in-chief, and I won't fall for it.
Considering that the president, in his first term, actually ordered such a thing, it is not a premise that you can reject. He can order, do the same thing. So you're, again, I think you would just follow what the president wants you to do. Let's face it, it is not normal to call up our troops in this way, and there is active litigation against this deployment. Will you follow a court's order regarding whether or not this deployment is legal? If the court says this deployment of troops into our cities is not legal, would you follow that court's order?
It's pending in the courts, Senator.
Well, when the court decides, would you follow the court's order, decision?
I don't believe district courts should be determining national security policy,
So
but
you will not be following the.
when it goes to the Supreme Court, we'll see.
Court. And unless the president decides to appeal, there you have it. So I take it that you don't consider district court decisions to be legitimate. Thank you, Mr. Chairman.
Civilians and officials view federal use of force for years to come. This hearing crystallized a stark choice. Do we accept expanded domestic uses of military power in response to political priorities? Or do we reaffirm the guardrails that protect civil liberties and preserve judicial review? The answer will depend on courts, votes, and public pressure. If you found this breakdown useful, like, subscribe, and share this video, and if there's a part of the hearing you want a deeper legal explainer about, tell us in the comments and we'll dive in.